Good afternoon. So we are a little bit more than halfway through our marathon conference. I hope everyone is having a wonderful time, learning a lot. I hope you're all collaborating with each other, figuring out ways that you can continue to cooperate. That's what this is all about. Our next panel is particularly interesting for me. I know it will be for you too. I think it's an extremely timely and cogent subject for us all, considering the current situation we find ourselves in and the conflict we've been discussing throughout this whole conference. So I'm very delighted to welcome our distinguished guests and colleagues and also you participants. In the aftermath of conflicts, the path to peace is not only about the cessation of hostilities, but also about addressing deep scars left on societies, communities, and individuals. International claims commissions play a vital role in rebuilding trust, restoring dignity, and laying the groundwork for a sustainable and lasting peace. Our panel today will explore these mechanisms from various perspectives, including legal frameworks, practical implementations, and the challenges faced in diverse contexts around the world. Our discussion will survey how these types of mechanisms, including reparations, not only claims commissions, operate in reality and within the realms of international law, their effectiveness in delivering justice and healing, and the lessons learned from past and ongoing cases. It's my sincere hope that we can take some of these examples from around the world and from history and figure out how we can apply them in a truly practical way to the situation we have before us today. I also want to just mention very briefly that unfortunately one of our panelists who had actually traveled all the way here to Yerevan to participate has unfortunately fallen ill. So we wish Ms. Darleen Seda very well. We hope that she will feel better. She's right now recuperating and healing back at our hotel, and we hope that she feels better and is able to get home safely on her flight home. But for now, we have this distinguished panel, and I'm going to start with Simon Meisenberg, if it's all right with you. We're changing the order a little bit, but I think this order makes a lot of sense in context, and I think you'll see why. So, Simon Meisenberg studied law in Germany and Switzerland and is a German attorney at law with a specialization in corporate and international criminal law. He currently serves as chef de cabinet and senior legal officer in the President's office in the Kosovo Specialist Chambers. Previously, Mr. Meisenberg was a member of the KSC court planning team in Brussels as a Chamber's legal expert. He has previously served as legal advisor at the Extraordinary Chambers in the Courts of Cambodia and senior legal officer at the Special Court for Sierra Leone in leadership cases before those courts. He has also assisted defense counsel before the International Criminal Tribunal for the former Yugoslavia. Please, we welcome your remarks.
Well, thank you for the introduction, and thank you for inviting me. It's really a pleasure to be here, and I must say that I've learned quite a lot in these 2 days, and it was really inspiring to see and hear the voices also of the victims. I will start first by noting that I will talk about reparations for international crimes that were afforded through a criminal process, establishing the individuality of a person and the responsibility of that person to compensate the victims for the harm suffered. And of course, we've been speaking today about the difficulty of initiating such criminal processes. I will speak about such reparations at the Kosovo Specialist Chambers, where I work. I will use the abbreviation of KC, or Specialist Chambers, because that makes it shorter, and I will stick with the 10 minutes that are allocated to me. As this court may be not familiar to everyone, I will start my presentation by briefly introducing this ad hoc court that was established in 2015. The KC were a established following allegations that certain serious crimes committed during and in the aftermath of the Kosovo conflict in 1998 to 2000 had not been investigated and prosecuted. A report issued by the Council of Europe found that specific crimes that were committed by the Kosovo Liberation Army, which was fighting for the independence of Kosovo from Serbia, remained unaddressed due to a climate of witness intimidation which prevented the prosecution of members of that group, in particular senior leaders of that group. This was a critical finding given the engagement of several courts and entities in the transitional justice process in Kosovo, like the ICTY that we heard of, or the UN Mission for Kosovo and the European Union Rule of Law Mission. In order to address these allegations, Kosovo and the EU agreed to establish separate and independent judicial chambers, that is the specialist chambers, to adjudicate the alleged crimes. Through this agreement, Kosovo delegated all necessary executive mandates, powers and authority necessary for the operations of the specialist chambers. It was agreed that the specialist chambers would operate according to their own law, would enact their own rules of procedure and evidence, and would have a seat in a third state, so outside Kosovo. According to the agreement, the judges and staff would be international only, so there are no Kosovo staff members at the court. Moreover, any sentence imposed would be served outside Kosovo. This unique and self-contained court would ensure that justice be delivered independently, impartially, free of political interference from Kosovo, and with full commitment for the safety and security, life and well-being of witnesses and victims. The KC was created as a temporary judicial institution and is concerned only with the criminal responsibility of individuals. The jurisdiction of the court covers crimes against humanity, war crimes, that occurred between 1st January 1998 and 31st December 2000, and which were either commenced or committed in Kosovo, or by or against citizens of Kosovo or the Federal Republic of Yugoslavia. The KC also has jurisdiction over certain offenses against the administration of justice when they relate to its official proceedings. This is important given the climate of witness intimidation in Kosovo. With respect to the victims of war crimes and crimes against humanity, the law of the Kosovo Specialist Chambers provides specifically that a victim's personal interest and rights in the criminal proceedings before the KC are notification, acknowledgement, and reparation. The KC rules include provisions relating to reasonable reparations to victims from an accused who has been adjudged guilty of a crime which has directly resulted in harm to a victim. It is important to note that only victims that have been specifically identified in an indictment may participate in the proceedings. This naturally reduces the number of victims that may participate in the proceedings, even though it has been accepted that family members may pursue a claim of a deceased victim. Since the establishment of the KC, 6 persons were charged of war crimes and crimes against humanity, and the same number of persons were charged for offenses against the administration of justice, mainly for witness intimidation. One of the first cases to conclude was that of Sadi Mustafa, who was found guilty of the war crimes of arbitrary detention, torture, and murder. And he was sentenced to 26 years of imprisonment by a trial panel in December 2022. In the meantime, the sentence has been reversed to 15 years by the Court of Appeal just a couple of days ago. 8 victims participated in this case against Mustafa, and it is important to note that the victims were all of Albanian origin and ethnicity, having suffered crimes through the allegations by Mr. Mustafa's group that they were collaborators of the Serbian forces. In addition to the sentence, the panel ordered Mr. Mustafa to pay an overall sum of 207,000 euros as compensation for the harm inflicted on the victims of the crimes for which he was convicted. The panel determined that compensation for each of the victims on an individual basis constitutes the most appropriate type of modality of reparation. It ordered varying amounts to be paid to each of the 8 participating victims, ranging from 2,000 euros to 80,000 euros. These amounts followed the Victims' Council request, which the trial panel considered to be reasonable and to reflect the scope and extent of the harm suffered by the victims. While the panel recalled that the responsibility to pay this compensation lies exclusively with Mr. Mustafa, they noted that he does not have means to fully comply with the order. Therefore, the panel emphasized that other actors needed to step in order to execute the reparation order, in particular Kosovo. In this regard, the panel indicated that Kosovo's current crime victim compensation program could be an alternative to execute the reparation order, although the maximum sums which can be afforded under this program are less than the amount established in the reparation order. Therefore, the panel invited Kosovo to create a new reparation mechanism for victims of crimes within the jurisdiction of the KC in order to ensure an equal treatment between the suspects and accused before the KC. Here, it is important to note that Kosovo has established a fund to financially support the accused before the KC without any means testing, meaning that, that it's not being tested whether the accused would be able to pay the defense fees by his own means. No similar fund has been created for the victims of crimes falling under the jurisdiction of the KC. Furthermore, the panel observed that the legislation in Kosovo addressing harm and injuries suffered in the context of the war refers exclusively to victims of the enemy forces, that is, not the armed groups that were fighting for the independence of Kosovo, which, in the view of the panel, created a discrimination between the victims of the armed conflict in Kosovo. In addition, the panel recommended the establishment of a trust fund for victims of crimes under the jurisdiction of the KC at the initiative of the KC in case that Kosovo fails to uphold its obligation towards victims in a reasonable time through the establishment of a reparation mechanism. Such trust fund should be financially supported above all by Kosovo as well as by other states and donors wishing to support the victims. A single judge has been designated in order to follow up on the order and to monitor and oversee the implementation of that order. This case illustrates that reparations may be a tool to compensate the suffering of victims. It, however, also shows its limitations, in particular in cases where the perpetrator is indigent and cannot pay the reparations ordered by the court. The judges have outlined the insufficiencies of the compensation programs by Kosovo and how they have looked at other possibilities, looking into a direction of a separate fund that could reasonably substitute the compensation by the perpetrator in order to provide a measure of compensation to the victims. And I'll stand ready for any questions afterwards. Thanks a lot.
So here we go. All right, so our next speaker is going to be Professor Garry. Professor Garry is a professor from practice and executive director of the Promise Institute for Human Rights at UCLA Law School. She's an internationally recognized legal scholar, teacher, and advocate with over 25 years of experience, spanning more than 25 countries in human rights, international criminal law, international refugee law, and transitional justice. One second. There's much more, trust me. She's a widely sought expert with extensive public impact, including having served as amicus curiae before the United States Supreme Court, the International Criminal Court, as expert witness before the UN Human Rights Committee, UN Office of High Commissioner for Human Rights, the UK House of Lords, and many other tribunals. Professor Garry has successfully advocated on behalf of hundreds of refugees and victims of genocide, war crimes, and crimes against humanity in multiple jurisdictions, including the ICC, the UN Yugoslav and Rwandan tribunals, Cambodia Tribunal, the Lebanon Tribunal, UN Human Rights Council, and multiple UN human rights treaty bodies. She's also the founding director of the USC Law School's International Human Rights Clinic, and she is a widely published scholar with many prominent scholarly journals that are way too numerous to name here. And we welcome you here today, so please take the floor. Professor Garry.
Well, good afternoon, everyone, and thank you so much, Talin, for that introduction. Thanks to you all for such a wonderful conference so far, and I just want to give a shout out and thanks especially to Judge Garcia and also the whole team of CFTJ for just so warmly welcoming us, and I just congratulate you on such a well-organized conference. Being an executive director of an institute, I know how much time and effort and planning goes into all of this, so it's really well done. And I just want to say, too, it's my first time to Armenia, and it's a wonderful place and country, and I've been warmly received, and I hope to come back many times. So today I've been asked to summarize some points on an article I was recently working on with regard to the Eritrea-Ethiopia Claims Commission as a form of international claims commission. And as you heard from my bio, my background is really international criminal justice and accountability through international criminal trials. So you may be wondering, why am I thinking about an international claims commission? And it somewhat relates to comments earlier today that were raised by Dove and Philippe and others. I'm puzzled by the trend since the early 90s in thinking about international criminal trials as the primary, the most important form of transitional justice to throw our energies and resources into. And believe me, I'm a believer in accountability, individual accountability for perpetrators, for sure, and have spent a lot of time working on those cases and trying to raise the voices of victims through Article 15 submissions to the ICC and in other ways. But it seems to me that there's been less attention paid to the full range of tools in the toolkit for transitional justice. And so when I was a young attorney, just getting started, I did a year on Wall Street in big law and had the opportunity to assist commissioners at the Eritrea-Ethiopia Claims Commission for award of compensation to victims of that bitter international armed conflict, namely civilians and prisoners of war as protected persons under the laws of war. And they had the opportunity to bring their claims to this commission and receive compensation. So it really puzzled me in my teaching of international criminal law and thinking about transitional justice that these claims commissions hadn't been labeled as transitional justice mechanisms. And so what I try to do in this article that I've been working on is, firmly sort of place these claims commissions within the transitional justice toolkit, and then also to think about their efficacy and ways that they can be improved moving forward, and also complementarity to international criminal trials as forms of justice. So the Eritrea-Ethiopia Claims Commission, as I mentioned, focused on atrocity crimes, namely war crimes. And a lot of the facts that were considered by the commissioners are similar to what the victims in Artsakh recently went through. And tragically, as we know, the world witnessed such crimes and largely stood silent in the face of Azerbaijan's attack and seizure of Artsakh on September 19th, 2023, resulting in multiple civilian deaths, dozens of injuries, destruction of civilian property within the first 24 hours of the attack, and massive forced displacement in a very short period of time, as we have all heard. Of course, this attack also resulted in seizure of private property, homes, and damage to cultural heritage sites. And in light of all of this grave harm against over 150,000 ethnic Armenians, 25% of them children, this was following on the heels of course, as you've heard, a 300-day blockade of the Lachen corridor. So they were fleeing in the midst of a humanitarian crisis, but it also followed the 2020 war. So you have to set all of that in context, and I just outline all of the harm because it's important for understanding then how these claims commissions might more holistically address all of the harm in an atrocity situation. And it's my hope that the experience of the EECC, which I'll outline for you, and lessons learned might prove helpful as we think about the possibility, indeed, in my view, the necessity for an international claims commission or some sort of registry of damages as a pathway to more holistic justice for the people of Artsakh and all that they have suffered. So I'll start with a brief overview of the EECC for those of you who are not familiar with it as a particular form of International Claims Commission, and talk about its features that in my view make it a transitional justice mechanism. And then, as time permits during Q&A, I'd like to explore with you a little bit more why I think that they are an important complement to other forms of justice, like international criminal trials, even the tribunals that do allow for victim participation and reparation. I think there's a role for claims commissions to play. And then also talk about some of the lessons learned from the EECC experiment. So the EECC was established during peace negotiations with the signing of the Algiers Agreement, and that was between Eritrea and Ethiopia as states after their bitter conflict over the border from 1998 to 2000. And while it was modeled after historic mixed commissions, which are typically arbitral bodies that are set up for state-to-state claims, so states sue each other for compensation. It was a mixed claims commission, meaning that it allowed for individuals also to bring claims, and that's important to note. So mixed claims commissions are defined as bodies founded ad hoc on the basis of some binding international legal agreement established for the purpose of usually settling compensation claims for monetary award, which have arisen between individuals of different states, between individuals of one state and the other state, or between the states themselves. So as an ad hoc arbitral body, each side in the conflict chooses two arbiters, and here in the EECC, they were non-nationals, and then the party-appointed commissioners chose a neutral. The EECC had jurisdiction over mass compensation claims, which is important to note. So they were able to process claims for reparation by tens of thousands of individuals who suffered, as I noted before, grave harm due to violations of international humanitarian law or war crimes. And in this particular conflict, an estimated 50 to 100,000 were killed and close to 1 million forcibly displaced, most of them civilians. Many were detained, tortured, and expelled as prisoners of war. There was also widespread damage to civilian buildings, property, and infrastructure. So this structuring of the EECC to allow for individuals to bring their claims for grave human rights abuses and international crimes was very much in line with precedent that we've seen since World War II with the establishment of different claims processes. And this is not a surprise because of the development of international human rights law and human rights norms focused on individuals as rights holders under international law. So, for example, the Holocaust claims processes, and then we've seen MCCs such as the UN Claims Commission established by the Security Council following Iraq's invasion of Kuwait. And increasingly, these jurisdictions have been able to consider claims, again, from individuals, not just states, and often massive group claims. So, for example, with the UNCC, they considered over 2.7 million claims from individuals, awarding $52.4 billion to 1.5 million claimants. The scope of the claims that were brought is also important to note before the EECC. The claims were broad in nature, so they addressed not just physical injury or grave harm that we often see to large populations in the context of international crimes that violate civil and political rights. The claims also included socioeconomic and cultural rights and harm to the environment and promotion of peace and development for affected communities as equally important for individuals to bring for seeking compensation. In the end, after nearly a decade of hearings at the Permanent Court of Arbitration in The Hague, the EECC's awards eventually provided for lump sum payments to be paid out by the respective states to each other and their nationals as follows. So Eritrea was awarded a total of just around 162 million for 16 different findings of liability against Ethiopia, and also awarded a total of over 2 million for 5 individual Eritrean claimants. Ethiopia received compensation in the amount of about 174 million for Eritrea's violations of the laws of war and also for having initiated the conflict in the first place. So turning now to, with that overview, I now turn to just highlight some of the features that, in my view, make it a transitional justice mechanism. And here I'm looking to the definition of transitional justice established by the UN Secretary General's 2010 guidance note, which includes, quote, the full range of processes and mechanisms associated with the society's attempts to come to terms with the legacy of large-scale human rights abuse in order to achieve accountability, reconciliation, truth, reparation, and non-recurrence. So the following features of the EECC point to it as being a transitional justice mechanism. First, from the outset, if you look at the Algiers Agreement, its founding document, transitional goals are noted and are prioritized within the document. And the EECC in its work was coupled with an investigation by the OAU, the Organization of the African Union, as well as another commission, the Boundary Commission, to consider where exactly the boundary lie after the dispute between the two countries and territorial rights. And so the EECC was part of a broader effort to bring reconciliation between the two countries, and in doing so to try and restore peace and security to the region and non-recurrence. Second, as a Mixed Claims Commission, the EECC, as I've already noted well, had a lot of focus on individuals and their claims for damage. Third, there was allowance made for the EECC to hold hearings close to the victims and affected communities if the commissioners considered it appropriate. And fourth, in deciding specific claims for state responsibility during this conflict, the commission, of course, in doing fact-finding, engaged in a form of truth-telling and establishment of the historical record as they made decisions on the claims and issued their awards. Fifth, when finding either Eritrea or Ethiopia in violation of international law and ordering monetary awards, through binding decisions, measures of accountability and reparation were achieved. And then finally, I will close with just noting that various structural features of the Commission allowed for a legitimate process, which is important from a transitional justice perspective. Not only was there international oversight and facilitation by other countries, as well as the UN and the OAU in establishing the Commission, but the appointed commissioners were required to serve as impartial neutrals, and further, there was notable procedural flexibility allowed for the conduct of the proceedings, making them bespoke or tailored to the specific context of this conflict. For example, with reference to adoption of measures that allowed for justice through mass claims processing in light of the numbers of victims of the war. And finally, the emphasis was placed on making the EECC an expeditious process with clear deadlines, both with regard to the filing of claims, but also rendering of decisions, potentially leading to timely satisfaction for the victims. So I highlight all of those features that, if followed, would have made it a robust transitional justice mechanism. Of course, in reality, it didn't necessarily play out to be such, and so we can talk about that more during the Q&A. Thank you.
Thank you so much, Hannah. We will have much to discuss in the Q&A session about that. Our final speaker today is Ms. Anna Pacurar. I apologize, I don't know if I'm pronouncing that correctly. Anna is a student assistant at the Chair for International Criminal Law for Professor Christoph Saverling at the Friedrich-Alexander-Universität Erlangen-Nürnberg. Previously, she worked on the field of claims and reparations of victims of the Holocaust and their heirs, which allows her to provide useful and practical insights on this issue. We welcome you. Thank you.
So, good afternoon. Thanks for having me. As Talin said, I will cover the issue of the so-called reparations agreement between Israel and West Germany following the atrocities of the Holocaust. Also known as the Luxembourg Agreement, this agreement constitutes a landmark in post-war diplomacy, as it has the potential to set the precedent for state-sponsored reparations for war crimes and genocide. The negotiators met in seclusion in a Dutch town of Wassenaar spending several months from March 1952. There were three major parties to the agreement, which was ultimately signed on September 10, 1952 in the neutral Luxembourg. So the parties were obviously the Federal Republic of Germany, at the material time West Germany, represented by the Chancellor Konrad Adenauer, then the State of Israel, represented by the Prime Minister David Ben-Gurion, and Foreign Minister Moshe Sharett. Israel made it clear that the reparations were necessary not only to compensate for the suffering of the Holocaust survivors, but also to help the young nation absorb tens of thousands, hundreds of thousands, in fact, of Jewish refugees. The third party to the agreement was the Conference on Jewish Material Claims Against Germany, also known as the Jewish Claims Conference, or Claims Conference, let's just call it the JCC, which was represented by Nahum Goldman, the president of the World Jewish Congress. And the JCC was established to represent the interests of Jewish Holocaust survivors, particularly in the diaspora, so outside of Israel. The agreement ultimately resulted in two major reparations. First of all, it were the reparations to Israel, where West Germany agreed to pay approximately 3 billion Deutsche Mark to Israel, primarily to rebuild the state and support the resettlement of Jewish refugees. And this sum, to give you a rough idea, corresponds to the to 1/9 of the federal budget back then. So an additional 450 million Deutsche Mark went to the Jewish Claims Conference to compensate victims, as I said, in the diaspora. It is important to note that the pre-negotiations time was full of obstacles because Israel, which had taken the initiative, first didn't want to negotiate directly with the German government. And also after the agreement, there were severe uprisings taking place in Israel, since the negotiations would indirectly mean the recognition of the Federal Republic by Israel. And this would in turn represent a breach of the symbolic ban imposed upon Germany, that Israeli passports at that time bore note that they were valid for all countries except for Germany. In January 1952, tens of thousands demonstrated in Tel Aviv. Both the right and the left complained that the memory of the murdered cannot be sold for money. In order to refute the accusation of blood money, the Israeli delegation, as well as the JCC, strictly separated material benefits from moral recognition. So this also is very visible in the name. It's material claims against Germany, and not it's not speaking about morals. So some Arabic states also protested against the ratification of the hard-won agreement, fearing, of course, that Israel would be strengthened militarily by the reparations. And in West Germany, there was also a fear of a damage to the, let's call it, traditional German-Arab friendship. And also the German Democratic Republic was trying to nurture its relations with the Arab nations, so there was also very tense diplomatic context here. And the German diplomacy countered the Arab critics with a recommendation that the Luxembourg Agreement could be actually a kind of model for compensation for the Palestinians expelled from their lands after the first Arab-Israeli war in 1948. And in order to stabilize the balance between its relations with Israel and the Arab nations, from 1952 onward, West Germany transferred funds to the United Nations Relief and Works Agency for Palestine refugees in the Middle East on several occasions as a kind of compensation for payment to Israel. So how is this all relevant, or history relevant here? Today the Luxembourg Agreement is an important example for other compensation claims, which leads us to a very complex question. Why was there a Luxembourg Agreement after the Holocaust, but not after the killings in German Southwest Africa? This question has started important political discussions, of course, about the Holocaust, about how the Holocaust is different from other tragedies. In 1952, Israel and the Jewish Claims Conference convinced West Germany to negotiate by saying that the murder of Jews was unique, and now Germany often utilizes this idea of uniqueness to deny other compensation claims, not just for colonial crimes, but also for other issues related to World War II, like claims from Greece or Poland. On one hand, so the Luxembourg Agreement represents what the German President Steinmeier called a miracle of reconciliation when he visited Yad Vashem in 2020. On the other hand, it shows a lack of compensation for other historical tragedies, and in some cases, this agreement has even become a part of a sort of competition among victims from different histories, which is just as problematic. However, both these points of view overlook something important about the 1952 agreement. It was successful because it focused on the survivors and not the murdered. Some scholars even argue that this decision not to talk directly about genocide helped create the first agreement for genocide compensations to individuals and not just to states. And this is where the switch or the shift from a passive victim towards an active survivor also becomes relevant. I would like to conclude with a quote of Gershon Scholem, a Berlin-born historian and philosopher of 1966. The quote stems from 1966. Abysses are flung open by events. Bridges are built by goodwill and conscious thought. If the bridges are to endure, they must be firmly anchored on both sides. Where love is no longer possible, a new understanding requires other ingredients, such as distance, respect, openness, and open-mindedness, and above all, goodwill on both sides. Thank you.
Wow, we have three excellent examples there, very disparate in their relationship to victims and their relationship to perpetrators. There's a lot to digest there. Let's just simply start here. I want to understand more about the KSC and its function. So, Simon, would you mind telling us a little bit more about the reparations process in the KSC, and specifically, does the KSC allow for reparations to victims who have not directly participated in proceedings?
So to start with the last question first. So in order to receive reparations, a victim has to participate in the proceedings. So there is an application process at the start of the proceedings that any victim can apply to if they are directly mentioned in the indictment, or the family of a deceased victim that is mentioned in the indictment, but otherwise reparations would not be possible.
And I'm interested to know, just as a quick follow-up, from the point of view of the function of transitional justice, how do you view the role of the KSC as a tribunal in that function?
Okay, that's a very complicated question. So we have to understand that the Kosovo specialist chambers were created because of a lack of accountability for certain perpetrators in Kosovo. We had other accountability mechanisms that were addressed also in this conference with the ICLU in particular, that also prosecuted leaders of the Kosovo Liberation Army, and of course there were also trials in other mechanisms like the unmake panels or the ULEX panels. However, as I mentioned, there was this lack of accountability for a certain group of persons, and in the Council of Europe report it was noted that that there was a glass ceiling where basically certain people couldn't be reached because of witness intimidation, and therefore it was found necessary that a court would be created outside Kosovo. Now, in terms of the transitional justice mechanism in terms of Kosovo, of course, it's a difficult relationship because we're prosecuting the former president of Kosovo and other senior leaders that are being considered war heroes in Kosovo. So it's a very difficult relationship for that country as well. And I think there has to be also an understanding of that because they achieved independence, and now in Kosovo, there are voices there saying that through this prosecution, of course, a certain narrative is being changed. Now, the other opinion is, of course, that through such a process, we're discovering, or we're just serving accountability, and that's what the court is doing. Whether that in the end concerns the transitional justice process between Kosovo and Serbia, that's a very difficult question.
Professor Garry, I want to turn to you. I want to stick on this notion of transitional justice that you addressed in your remarks. And I wonder from your perspective in the Ethiopia-Eritrea Claims Commission, what was the importance of transitional justice, or how in your view was transitional justice sort of served through that tribunal? And if you wouldn't mind also answering, what is the importance of considering the establishment of a mixed mass claims commission, something that we might be able to conceptualize for the situation relevant to Nagorno-Karabakh in the context of transitional justice?
Great. So, can you hear me? Yeah, okay. Pull it up here. So in terms of the transitional justice served by the EECC, I think primarily it was about focus on the victims and reparation and compensation, and that was an important role that it tried to play. But of course also other transitional justice goals were met in the process. So with the review of claims and the findings, there was, as I mentioned earlier, some sort of truth-telling, some sort of establishment of facts in the historical record, and that's important, right? There was also accountability, and I think one of the important roles of these claims commissions is recognizing that accountability is not just about individual perpetrators, but it's also about states and state responsibility. And so these claims commissions allow for claims against entities, and here the entity was the state, but you could also imagine potentially, setting up a process that allows for other sorts of entities to also be held responsible, say corporations, other non-state entities. I think that finally what I would say is that the Claims Commission allows for process, allows for transitional justice in my view, a more holistic way, because the claims, the process, the setting up of the ad hoc arbitral body, all of it can be created, and it's bespoke. It can be tailored to a specific context, and that's not the same for international criminal trials, right? And then the second question was about international criminal trials, is that right?
Sorry, so then, so that was a discussion about the EECC, so let's try to extrapolate those lessons and see how we can apply them to Nagorno-Karabakh, if we can.
So I think that some of the lessons that are learned, so that as many of us know, right, the conflict, it did not bring peace and reconciliation. The EECC, you know, for all of its goals for transitional justice in the Algiers Agreement. And there's a couple of reasons for that, I think. One of the lessons learned was that the creation of the Claims Commission was very top-down. It was, the victims did not have a seat at the table. They were not a part of the Algiers Agreement and the peace process. And I think it's really critical for these commissions to really be successful that the victims are a part of creation of it from day one, making sure that it really reflects their need, their interests, what they want for justice. So it needs to be what is called in the literature transformative justice, right, from the ground up rather than top down. Another is that you know, I think a good lesson learned from the EECC was its focus on, you know, at least naming transitional justice goals as central to the process, but that needs to be maintained throughout the whole process, not just within the language of the founding document or the agreement. Another good lesson learned from this process is the importance of outsiders, outside oversight from here we had the OAU and other states to make it, you know, to make sure it was a neutral, sort of impartial process. I would say, though, that one of the big reasons the EECC was not entirely successful was that claims were never paid out, and there was lack of resources, right? And so, and if you noted from the numbers I listed, essentially the awards found damage and liability roughly in the same amount on both sides, so they canceled each other out. And they were meant to be paid in lump sum if they ever were paid, which is not ideal for the victims, right? So it goes to the states, and then it's up to the states to pay out to the victims. If the money had been paid out, there needs to be oversight in terms of making sure that the money is not lining corrupt pockets, right, in the aftermath. So, and then the other role that outsiders need to play, like international organizations, other states, is in making sure that that there's funding. So I think that, you know, this could have been something, you know, I know it's not easy ever to find resources or political will to establish these bodies, but it really there needs to be careful thought paid in advance, because you set up expectations with victims and then nothing is ever paid out, and it results in re-traumatization. And then last, I would just say that the EECC really highlighted the importance of access to justice for victims in the process. And although the Algiers Agreement made provision for hearings close to the victims so that they would have a sense of justice, that never actually happened. All the hearings were held in the Peace Palace in The Hague. Furthermore, individuals in the end were not really allowed to bring their claims directly. They were espoused by the states, and part of the reason for that was that the commissioners were overwhelmed with the complaint process and didn't know how to assess them as evidence and deem them of uncertain probative value. So in the end, just threw them out and decided to just have states espouse claims on behalf of their nationals. So that was not ideal, obviously, for victims. And then, as I said before, the expenses of the operation, they were enormous. You know, arbitration panels and bodies are not cheap. And so in the end, I think the expenses paid by the states for this process undermined any of that getting to the victims, which was really unfortunate. And so in the end, I think for some of the victims, perhaps the process was seen as merely symbolic justice, if justice at all.
Thank you so much for that. On this issue, you brought up a really, really important point, and I'm glad you addressed the sort of elephant in the room, which is when you say that so-and-so amount of dollars was awarded on either side, it was never actually collected. So there were awards that, in essence, canceled each other out because both Eritrea and Ethiopia were found to be liable, but nothing was ever paid. So that's difficult when you think about the actual cost, the administrative cost of having gone through and making it sort of in the end sort of symbolic justice. So, and I want to ask you a question sort of related about the administrative costs of the Jewish Claims Conference. what can you tell us about what the costs were? And also, I'll ask you a two-part question. What were the costs? And then also, how did that relate to, in the end, the damages that ended up being paid out pursuant to the Luxembourg Agreement?
So it has been criticized very often that the administrative costs were too high. But as a financial report, I believe, of the JCC of 2021 clearly states that it was just 5% of the amount that of the total budget of the JCC was spent on administrative costs, which is considered minimal, in fact, for a non-profit of this size. So this is one of the criticisms that you addressed, but there were also other criticisms connected to the JCC. For example, there were some fraudulent processes. There were, for example, in electrical excursion. So in 2010, there was a huge fraud that emerged in, I believe, in the United States. And it was discovered that nearly 57 million US dollars were misappropriated. And the JCC, of course, worked with the authorities, and it led to convictions of individuals, which in turn led to another problem that JCC is facing now when working with claims applications, and that is a huge delay in the application process, because if everything has to be double-checked, then obviously it will take longer. So one issue has been solved, but another arose from the solution. So I guess there will always be some ups and downs. You can never really, if you have an organization of this size with that is active in some 47 countries worldwide, it's almost clear that it will face some difficulties.
Thank you. Thank you very much. I want to stay on this topic for just one moment and see if we can learn some lessons that we might be able to apply, let's say, I'll be optimistic, 5 years from now, we actually start to discuss the possibility of a claims commission or some sort of transitional justice mechanisms for the context of Nagorno-Karabakh. What are lessons that we can learn? And particularly, I'd like to ask it this way. If you could look at your mechanism that you've discussed here today and change one large thing about it, if your design were to be applied to a new conflict, post-conflict situation, what would be the largest changes you would make? Can I start with you, Professor Garry?
Well, it's what I said earlier, which is I really think that the voices of victims were totally lacking from the process, and that's critical. And so today, I understand, and I'm learning a lot today about the conflict, the ongoing conflict, and then the deportation from Artsakh. And I understand that the ongoing negotiations for peace don't have the voice of victims at the table, and it seems to me that's very problematic. Generally, but also problematic from the perspective of any kind of claims of reparations.
Really quickly on that, I would just like to note that in almost all of these situations that we discussed where some sort of mechanism was established, it almost always came out of a peace agreement. So the fact that the Armenia-Azerbaijan discussions have completely left this possibility off the table creates a little bit of a challenge for how we might be able to see this come to fruition. Same question to either of you about what's the main elements of your particular mechanism that you would change if you applied it to a new situation?
So I can only speak from the perspective of Germany, because I didn't really dive in that well into the conflict in Nagorno-Karabakh to be able to adjudicate on it or to give any recommendations. But from Germany's perspective, I would say it is very important to focus on all different kinds of victims, not just one ethnic, like not just the Jewish victims, but also it would have been nice to see some focus on Sinti and Roma that suffered under the Holocaust very immensely and that are not being really paid attention to. So this is a lesson, well, not a lesson, but it's something that still should be worked on intensely, and yes, this is like a really important homework.
So from the perspective of my presentation, of course, I'm talking about individual responsibility, and what we've seen in many of these trials at the international level, and probably also domestic level, is that the accused of these trials are very often indigent or have been able to somehow hide their wealth before they're being tried. And then, of course, the problem is that even if we have victims that participate in their proceedings, that very often then the accused who has been found guilty is not able to pay any compensation or the reparations. So there has to be a mechanism that would somehow then step in and compensate the victims, whether it will be with such big amounts as, for example, in the reparation order that I've talked about, where we have 80,000 euros per victim. I think that's probably not possible, but with small amounts that might be the case. Of course, the ICC has that possibility with the trust fund, but it also has its limitations. But it will be good to find some balance there, where then either state or there is some creation of a fund that would compensate victims.
Yes, please.
Another thing that's on my mind now is very important in every conflict that arises to collect evidence as much as possible. It's crucial to justice for the justice to be seen, and it's like the pre-step to any kind of remedy or reparation or even peace agreements, because sometimes you have to use this evidence as a tool of pressure for the other side to actually enter a peace agreement. So this is something I believe is missing at the moment in the case of Nagorno-Karabakh. Because lots of evidence has been destroyed. It's the only thing that they rely on, as far as I understand, is some Telegram channels that we learned during this conference. So it's mostly the Azerbaijani side that appears to deliver the evidence, but it would be good to see also some more accumulating evidence from the side of Nagorno-Karabakh people.
Thank you for that. Yeah, it's a particular challenge now, which makes the work of organizations like CFTJ all that much more critical when, Azerbaijan now has 100% effective control over all of the spaces where any evidence might be, so testimonies of victims is particularly of critical importance. Simon, I'd like to ask you, you mentioned about the reparations process and that the ICC has a mechanism in place that KSC doesn't. I wonder, could you elaborate on the system for reparations in the KSC and how it differs from the ICC?
Well, as mentioned, so at the KSC, we need to have victims have to participate directly, and only if they have mentioned in the indictment. And one of the big differences is what I've just said is that the ICC has the possibility of a trust fund. As I mentioned, the reparation order in the Mustafa case, the judges elaborated on that, but it's not existing. So it's something that has to be created, or basically Kosovo could also create such a mechanism. Of course, then there are also other problems in terms of the KC, and I know that I'm not responding to the question, but the problems are as well that if Kosovo will create such a mechanism, then it has to be somehow administered through the Kosovo Specialist Chambers, because we wouldn't want to give the identity of the victim away to Kosovo authorities, because they are protected and they deserve that protection and cannot be kind of disclosed through such a process of reparations. So that's something that is important as well, that where we wouldn't be able to then disclose that identity. So it has to be a process that will be administered through the Kosovo Specialist Chambers. And the main difference is, of course, that we don't have such a mechanism of a trust fund.
If we could create a roadmap, I mean, we're looking at sort of different mechanisms with different patterns, right? So we've got individual criminal responsibility, we have claims, and there's been mention from both of you that the claims commissions didn't necessarily have a victim-centered approach. And then we have the UNCC, which is an entirely other, Security Council established, very UN-centric established, very organized, with the funds and, the pot of money already in place, which was part of its incredible success, and the huge amount of mass claims that were able to be processed through the UNCC, that's a totally other story. So if we were to sort of try to imagine in concrete terms how we might be able to, let's assume that Armenia being, acceding to the Rome Statute means that we might not have to establish something like the KSC. So in terms of individual criminal responsibility, we might maybe someday be able to use the ICC, right? So let's assume that. So then we're left on the issue of processing of mass claims, loss of real property, loss of personal property. In your mind, and I'll ask this question of each of you, what should that look like? Who should establish it? Should we go to the Council of Europe and ask for a register of damages, as they have just recently established in Ukraine? Is that the right first step? What's the first step, and where's the money coming from? Professor Garry, go ahead. I know you have thoughts.
I'll give it a try. Well, I actually want to encourage CFTJ to think about, the great work that you're doing in gathering evidence, to think about also using that evidence for reparations purposes and documenting harm beyond establishment of international crimes, but also, damage to property, damage to cultural heritage, which also qualifies as international crimes, obviously, but for reparations purposes. And I think an important next step might be to, to push further for more fact-finding by outside bodies, human rights mechanisms and bodies, a commission of inquiry or something to establish, some of the facts that you need for then, forming the foundation for the basis for establishment of a commission.
Great. Thoughts?
Well, I'm not sure whether that really answers the question. The one thing that I've heard in this discussion is, of course, how to trigger the jurisdiction of the IC, and that the IC kind of steps in. However, looking at the IC, of course, the IC will even if we will come to a situation where the IC will be prosecuting potential perpetrators, it will probably not even be a handful, right? So it will be just maybe 2-3 persons, as we've seen in other situations. And the question is whether that's really sufficient for victims to see accountability. So there has to be, one has to think about other models of justice as well, if we want to have criminal justice, and therefore maybe, other models of justice. I don't want to advocate for the KC model, but other models of justice have to be looked into, because just relying simply on the IC probably will not be sufficient.
Yeah.
My co-panelists presented some very practical ideas, but I think there is, also very important, apart from the practical side, and that is that the Armenian people all over the world feel the same, that they are pulling on one rope, so to say, and that they talk to each other, that they share their experiences, and also speak out to other in their home countries, in the diaspora, let's say. So this would be a thing that I think Armenia should continue to focus on, especially strengthening the community. I think that is a very important aspect towards reaching any solution.
Great, thank you. That's a really important comment as well. I would be remiss if I didn't mention that I welcome audience questions. It doesn't look like any are coming in. I mean, I could sit here all day. I have like about 5,000 more questions for this illustrious panel, but you know, as we wrap up here, I'll welcome 1 or 2 questions from the audience. And if not, in a moment, I'll invite each of you to give us some final thoughts on your specific mechanisms and how you think they might apply, and also whatever you feel we should take away. But I just want to mention one simple thing. Is you mentioned, Professor Garry, that it may be time, or a wise step may be to try to trigger some of these UN mechanisms, investigative mechanisms, or possibly try to lobby in the HRC and other similar venues. So there is some hope, because I just want to make sure that we're keeping this in context, that the Special Rapporteur on the promotion of truth, justice, reparation, and guarantees of non-recurrence has actually visited the Republic of Armenia. UN Special Rapporteurs only get about 2 country visits per year. It's very encouraging that last year this particular Special Rapporteur visited in November, which was only about 2 months after the completion of the displacement. CFTJ worked very hard on issuing a report to the Special Rapporteur before his visit, and his recommendations were published in July. So I'm very encouraged by that. It's a wonderful first step. It's starting this dialogue, starting these steps. And I would just note, there's a lot of great recommendations in here, but the one that I want you to take particular note of is at the very, very end of the document, recommendations addressed to the international community, which says that the Special Rapporteur recommends that the international community ensure that parties to peace negotiations and members of the international community relevant to such process include, in any discussions or agreements concerning the former Nagorno-Karabakh region, the adoption of mechanisms of truth, including facilitation of search of missing persons and fact-finding processes, criminal accountability, reparation for victims, the preservation of archives and the cultural heritage of the population of Nagorno-Karabakh, and guarantees of non-recurrence, in consultation with the affected population and victims, and establish such mechanisms under the auspices of the international community in compliance with international standards. So it's really encouraging that that recommendation was already mentioned, and hopefully it will be sort of a bridge, a stepping stone that we can actually take the next step. So I'm encouraged by that. And with that, I'll just offer the floor to each of you for some final thoughts. We'll start over here, and then we'll come back around. So Simon, if you don't mind.
Sorry, the last, so was there any question, or just last comment?
Just last comment.
Well, last comment would be, especially like an invitation to CFTJ, if you're in The Hague, just come to our court and have a look.
Great.
So I think the main lesson of the Luxembourg Agreement is to prioritize long-term resettlement over short-term political gains, and this is crucial to establish peace between two conflicting countries or nations.
Yes, my final words would be about I mean, the Special Rapporteur said it best, but it really is important and critical that as we move forward, whether it be with international criminal trials and push for those at the ICC or through universal jurisdiction or national trials, or push forward with claims commission processes or any other form of transitional justice that the victims be represented. It's just critical, and I don't see them represented well in this particular conflict, and their interests seem to be at cross purposes with the political winds at the moment, and that's really problematic for long, as was said, for there to be peace, long-term peace, and for there actually to be holistic justice here.
I think that's a wonderful place to end. Thank you very much to our panel.